Hello everyone, welcome to this video on warranties and damages. So we're going to be looking at what damages can actually be claimed during a contractual dispute or as a result of one or more parties not fulfilling their obligations within a contractual relationship, as well as specifically looking at warranties, which is a distinct type of term, so not quite the same as having a breach of a normal term or a breach of a condition. So if we start as ever with the basic question of what damages can actually be claimed in a contractual dispute, well, we have three distinct actions or potential actions that can give rise to damages being claimed. So the first is relatively straightforward. It's where a party or one or more parties within a contractual relationship fail to perform their obligations in whole or in part. So this gets to the heart of the contract. A contract is an exchange of mutual obligations. So if either an entire obligation is not performed or is performed in a way which renders part of it null, that sounds vague because it is necessarily vague, and there is quite a bit of dispute, and often judgment is required to discern whether an obligation is partially unfulfilled, but usually is relatively straightforward and easy to spot where one of the parties actually falls foul of this and they haven't discharged or performed their obligations that they have to within the contract. The other two are slightly different, and they don't actually necessarily conform to a breach of obligation. So the first is where there's demonstrable intent not to perform their obligations in the future. So parties do not have to wait until the obligation isn't performed if there's a conditional obligation or there is a time span actually set within the terms and conditions of the contract. If there's demonstrable intent, then they can actually claim damages ahead of time. There is obviously a fairly high bar for this. Simply not answering the phone or not responding to contact is not demonstrable intent. There has to be something higher. It can, for example, be stated or agreed upon verbal conversations where this intent was conveyed, or it can be through inference of action. So if action is quite clearly demonstrating intent to not perform obligations, so if, for example, there is an employment contract where work has to be carried out on a particular date, but the employee has made plans and is out of the country, and plane tickets are booked and hotels are booked, then that can be inferred through their actions that they have the intent not to perform their obligations on the date specified. So the other party does not have to wait until that date is passed. They can actually claim damages before. And the third type of damage or third action that can give rise to damages are acting in a manner which makes the obligation impossible to carry out. So this isn't a failure to perform their obligations and isn't necessarily meeting the bar for demonstrating intent not to perform their obligations. But if there is other actions that have been carried out which makes either the core commercial purpose of the contract moot and no longer valid, or arranges circumstances in such a way that the contractual obligation simply cannot be carried out, that can give rise to damages, but there has to be a clear path from the actions of one of the parties to the obligation not being possible to be carried out. So this would exclude things that are obviously outside of the ability of one of the parties to control. That would fall under typically things like force majeure clauses or act of God clauses, and it cannot be something which is incidental. It has to be something which is meets quite a high bar in being clearly aimed making one of those obligations impossible, and the impact must be certain. So the party has to have had certain knowledge that their actions would cause this obligation to be impossible. It cannot be something which is incidental, or something which is which is not certain, so something which may have a minor chance or a small chance of the obligation becoming impossible, but rather something which is clearly going to render that obligation impossible to carry out. So those are the three fundamental types of actions that can lead to damages. In terms of how we categorize them, they will be categorized again in three distinct sections. So you have a breach of condition of the contract, a breach of term, and a breach of warranty. We've already looked at conditions and terms, or terms and conditions, and how they can give rise to different ways of redressing the relationship. So both can give rise to damages, but conditions can uniformly give rise to the option of terminating the contract, whereas terms have to be considered to be sufficiently serious and strike at the heart or the purpose of the contract before they can give rise to termination. So only in particular circumstances could that happen, but both of them can give rise to damages. The third element here that we haven't looked at in the previous video is warranties, and how warranties also, if a warranty is breached, can also give rise to damages, but not termination. So if we just take a few moments to look more closely at what a warranty actually is, it's another one of these terms that we're quite familiar with normally, simply from either claiming something on warranty, having repairs of consumer goods, but it does have some additional elements that we should be aware of. So fundamentally, a warranty is an assurance or a binding assurance given by the seller, usually of a product, to the buyer regarding the state of the product. That can be about the performance of the good, it can be about some quality characteristic of the good, or it can be about the performance of the service. So it's not necessarily a product. Services can absolutely have warranties too. However, we should distinguish between serious breaches of terms and breaches of conditions, because a condition in particular, and also certain terms, are considered to be vital to the contract, to the purpose of the contracts and the theme of the contract, but warranties are ancillary, so they are there to formalize the assurances given by the seller, and to enable protection for the buyer in the form of damages. However, they are not considered to be vital to the contract, so it doesn't mean that the relationship itself can be terminated. So they would only give rise to damages rather than also giving rise to the option of termination. Warranties are often express warranties, so you will have warranties written into the terms and conditions of the contract, but this isn't necessarily needed. So you do have the ability to extend what the warranty covers, to be precise about the nature of the product or service, and what the warranty will act to assure the buyer will happen or will be provided. But there is an implied warranty for new goods that is not superseded by the express warranty. So express warranties can act to give more specification or give more information about the good or service. They can actually extend the implied warranty, but they cannot restrict the implied warranty. So what you cannot do is have a clear implied warranty and then through the use of an express term actually restrict or reduce that implied warranty. So if we just take a moment to consider what an implied warranty would actually be, well, this would apply to new goods and services rather than used products. So used products is a presumption in English common law that used products are sold as is. So if the seller of a used product makes specific representations, so not expressions of opinion, but actual representations as to the state of the used product, then that could be taken as a warranty, and often is. But otherwise, there's a presumption that there is no given warranty for a used product, and that they are sold as seen effectively. However, new goods and services are sold with an implied warranty that the goods are as advertised. So the exact state of the warranty depends on the representations made by the seller, but also that they are fit for purpose. So if there's a presumption, and a reasonable presumption, that if you buy something which is car shaped, labeled as a car, appears to be a car, and there are representations made that it is a car, then you cannot have an express warranty which says that this car shaped object is to be used as an emergency shelter, and there is no express warranty that it'll actually move and take you from place to place. So there is protection there for buyers, that even through careful use of language and the avoidance of express representations, that if there's clearly a reasonable presumption that the product will function in a particular way, that does constitute an implied warranty. This is not the case, obviously, for used products. So if you have a buyer which purchases what they think is a used car, but there was no representation made that it will actually take you from place A to B and move under its own power, and that actually it just is a car-shaped object which can be used as a shelter, and you can sit in it and escape from the world, then there is no implied warranty there. So there is a clear distinction there between new and used goods, and what implied warranties will actually cover. There are some additional considerations, however. So firstly, that if there are any clear defects or issues with even a new good, if the buyer is either told about these defects explicitly, so careful representation is made. So if someone selling a brand new car does explicitly say, by the way, there is no engine in this new car, it's just really a car-shaped object, then that would mean that the implied warranty doesn't hold. Or secondly, if the buyer has the opportunity and is invited to examine the goods and to draw their own conclusions as to the state of the goods, then that too would actually reduce the implied warranty. So if the buyer had an opportunity to pop the hood and see that there was no engine in this new car-shaped object, then the implied warranty there would be reduced as well. So there are some limitations on how broad an implied warranty can actually be, but usually the test would be a reasonable presumption or reasonable assumption. Whereas express warranties can be far more particular, they can be far more precise, and they can also extend things, but there are limitations on how they can reduce the implied warranty. As we said before, because warranties are not seen as being core to the exchange of obligations, so in our example of a car-shaped object, one party is providing goods and the other party is providing payment. If there is a breach of warranty, you can seek damages, but you can't actually seek to terminate the contractual relationship altogether. That would be restricted for conditions and for those particular terms which are seen as particularly vital or necessary to the theme or the core of the contract. The last thing that we're going to do is actually just look at the types of damages that can be claimed. And here, if like me, you grew up on John Grisham novels and following kind of big American court cases, even though the US does primarily run on a common law system as a former colony of the British Empire, there are still some very significant divergences that have happened with regards to damages. Now, both the UK and the US legal system have a distinction between compensatory damages and punitive damages, and you can find punitive damages being applied in the UK, but all of the massive headline cases of someone suing a company and winning £50 million or £100 million are usually punitive damages rather than compensatory damages. And punitive damages are a lot more common in the US for historical reasons, which really can be boiled down to within the UK legal system, regulation of companies and regulation of corporate behaviour is usually seen as a function of governance. So, i.e., the UK government will pass laws and regulations that constrain corporate behaviour. And that is seen as the correct avenue to actually change behaviour in that sense of both corporations and I guess individuals engaging in commercial transactions. Whereas for historical reasons in the US, a lot more decentralized with a federal system, legal avenues for constraining and changing this kind of commercial behavior have become normalized. So punitive damages are seen as an important way to actually affect change in commercial transactions and amongst for corporate behavior. So we do have punitive damages in the English common law system, but the function is really distinctly different based upon the governance system and the political system that common law systems operate within. So the primary damages that will be awarded in UK contractual disputes will almost certainly be restricted to just compensatory damages. So these are damages where the goal is to put the innocent party or the party which did not commit the breach, contractual breach, as far as possible back in the position that they would have occupied if that breach hadn't occurred. Now, that is usually limited to direct costs rather than I really can't pronounce anything today. Costs that arise as a consequence of the breach. So we do have a further distinction here. So a good way to think about it is that if you had a contract with a seller to provide you with particular goods that you need to execute your service, or let's say you're a hairdresser and you have a particular hairdressing equipment that is due to arrive and be delivered by a seller, and you have a contract in place. If that contract isn't carried out, and therefore you subsequently are not able to carry out your service for your customers, you can have direct costs which can be directly attributed to that breach of contract. And some of those may be a particular appointments that you made on that day that had to be cancelled and subsequently weren't rescheduled. So that would place you back in a situation that you would have occupied if the breach hadn't occurred. But that does not include things like potential appointments that you may have made if someone had wandered in off the street and saw that you were open and you had all the equipment you needed. It doesn't cover things like loss of reputation or damage to perception amongst your customers either. It is quite limited on what courts and arbitrators and so on would consider to be direct damages from the breach itself. There are in many cases express warranties and express terms that could include certain classes of costs that arise in consequence of the breach, and in many cases those will be carefully argued over during the negotiation phase, but generally speaking, if that's not the case, if there isn't an express term in the contract itself, you are quite limited on the kind of compensation that you're able to draw upon. Punitive damages, on the other hand, are not aimed at actually restoring the original party to the position that they would have occupied if the breach hadn't occurred. So you would still have compensatory damages, but punitive damages are intended to be additional damages placed on top of compensatory damages, where the goal is to actually punish the party which has committed the breach. So this is really there to make up a public example of someone that has acted maliciously or fraudulently or in a manner which is needing to be discouraged. So when you see crazy cases in the US where huge damages have been awarded, you have to bear that in mind, that this is not intended to say, well, if this person hadn't slipped in this store, well, they would have earned £50 million, so we're going to award damages of £50 million. Often there'll be compensatory damages, which will be medical costs, loss of earnings, and so on. So you're placing the person who, let's say, slipped in an unsafe environment, you're placing them back in the position, as far as it's possible, that they would have occupied if that breach hadn't occurred. However, the additional sums will be considered as a punishment for the company that runs and is responsible for that unsafe environment. So they would be punitive. So again, whereas in the UK we would primarily deal with this through regulation, so there will be particular agencies responsible for this and branches of the government, and then that essentially becomes an issue that the regulatory body or the government agency would take up with the company. It wouldn't primarily be through punitive damages, but like I said, there are some cases where punitive damages are awarded in extreme cases, or cases where judges feel that there isn't sufficient regulatory oversight or there isn't sufficient mechanisms to actually separately punish the offending party, and therefore will award punitive damages.